welcome everyone to this AYBIL Highlights webinar, in which we'll be showcasing recent work published in the Australian Yearbook of International Law. We're really pleased that you're able to join us today. I'd like to start the webinar by acknowledging and celebrating First Nations peoples from across the world, and in particular pay my respects to the Ngunnawal and Ngambri people, who are the traditional owners of the land on which the ANU campus resides. We pay our respects to their elders past and present. My name is Esmé Shirlow, and I'm an Associate Professor at the ANU College of Law and also the Yearbook's General Editor. And as you may be aware, last year, the Yearbook, in collaboration with the Australia and New Zealand Society of International Law and our publisher Brill, launched the inaugural ANZSIL Student Paper Prize. And we received a really highly competitive field of entries traversing an array of different topics of international law. So the prize committee, which consisted of myself, Professor Karen Scott as ANZSIL President, and Professor Tanya Voon as an AYBIL editorial board member, really had our work cut out for us in selecting a winner for the inaugural prize. But one paper really shone through, and the committee collectively agreed that the paper entitled Quarantine Island, Australia's Health Policy and its Construction of International Law was a worthy winner of the prize. This paper engages with the ways in which the Australian federal and state governments have approached the regulation of disease domestically and globally from 1788 to today. It covers a subject that is both contemporary and significant in light of Australia's regulatory responses to the COVID-19 pandemic. And today's webinar really serves to celebrate the success of this paper's author, Rebecca Brown, and to preview some of the findings that she makes in her paper, which will shortly be published in volume 41 of the yearbook. I'm really delighted to be joined by three panelists to feature on the discussion today, and I'd like to briefly introduce you to them in turn. We're of course joined today by Rebecca Brown, who is winner of the inaugural ANZSIL Student Paper Prize. Rebecca is an LLB graduate of the University of Sydney with an LLM from the University of Cambridge, and she's currently undertaking a PhD in law also at the University of Cambridge, focusing on treaty negotiation within global health governance. We're also joined by Dr. Mark Eccleston-Turner, who is a senior lecturer in global health law at King's College London. He specialises in infectious diseases and international law, particularly the law of international organisations, pathogen sharing, and equitable access to vaccines in a pandemic. Finally, I'm delighted to be joined as well by Jonathan Liberman, who is Associate Professor in Law and Global Health from the University of Melbourne. Jonathan has extensive experience in developing and implementing law and policy within the global health sphere and has worked with WHO, governments and NGOs in this area. We're going to spend the next hour or so discussing our panelists' work on COVID-19, pandemics and international law before opening the floor for questions from the audience. So I want to begin our conversation just looking at some background and context to some of Rebecca's work and some of the work of our panelists. So Rebecca, congratulations again on your excellent paper. Your paper highlights, and I quote, the intrinsic tension between domestic concerns of states like Australia in relation to disease control and their approaches to international negotiations and global health governance. And so I guess my first question for you is, what are the key findings that you make through this approach and in your paper?
Thank you, and thank you very much for organising this webinar. It's lovely to be here. My paper looks at Australia's domestic policy and ideals, and as well as its international action at different time periods, starting at colonisation in the 18th century and moving towards present day. And through this sort of approach, you can quite clearly see how Australia's sort of peculiar circumstances at each time change and affect how it approaches its international organizations, its international negotiations, and its participation in international organizations and what it seeks for these. It means that sort of international negotiations become a way of it trying to fit international law to its own corpus juris, rather than sort of being part of a cooperative or collaborative system. Whether or not its own approach is sort of effective, helpful, or even sort of based in reality. So, for example, if we first look at in Australia's first involvement in international negotiations in the early mid-20th century, its approach is immediately marked, and it's immediately sort of against a lot of the Western countries that it tries to align with. for a relatively new participant, it sort of immediately goes out sort of all guns blazing, wanting it to extend surveillance periods far beyond sort of their incubation period for known diseases. It wanted to ban certain materials from ever going on a ship that landed in Australia. When signing conventions, it sought reservations that essentially went against some of the articles, requiring sort of compulsory vaccination certificates for any person. And all of this was against the approach taken by other countries. All of this was sort of shut down by other countries. And so it's quite curious to see the sort of very peculiar approach. So looking at that, I then looked at the domestic ideas and what was in Australia happening at that time such that it wanted to express these ideas. And you can see both in its sort of ideals and then conveyed then into its own domestic policy, this really strong idea of disease elimination and the prevention of entry of disease. And that it sort of from first colonization developed a very strong preoccupation with its border. In part, that's because it was an isolated island. It took at least 10 days for any ship to land in Australia. And it also saw Australia as sort of a new world free from the diseases of the old world. And so this idea led to this sort of preoccupation with keeping Australia that way, and led to its own domestic policies, particularly the Quarantine Act and the Immigration Restriction Act that provided for similarly sort of strong ideas where they wanted, extensive quarantine far beyond what was ever going to be necessary, sort of handpicking people who were allowed in to make sure they didn't have disease, and this sort of approach. So because of this sort of very strong, very comprehensive quarantine and immigration policy based around preventing any possible disease, when it went into the international sphere, Australia very explicitly wanted the same thing. And obviously that's not particularly good for a cooperative international system. So I think one of the biggest indications of this was that Australia is the only WHO member state to opt out of the what became the 1969 international health regulations, and so it very much was an island in international law vis-a-vis its approach to health governance, and also in its sort of in its approach internally as well. It saw it as this island.
Right. Thanks, Rebecca. And Mark, you've also explored these sorts of themes and tensions between what you've called globalism and statism, particularly in relation to a proposed pandemic treaty. To what extent do those tensions that Rebecca's paper discusses in relation to Australia also show up in the practices of other states in this space?
So thank you. So first of all, I just want to congratulate Rebecca for a fantastic paper. It was so interesting. I learned so much, and it's a really impressive piece of scholarship. So congratulations. In terms of the whether these principles or these ideals are generalizable, I think there's a couple of aspects to that question. The first is I think that most countries try to adopt the approach that Australia has taken historically, but haven't been as overt in sort of crafting policy in such a way. Most countries have the same concerns and the same desires and the same idea that within their country is safety and threats exist outside of that country. And all we have to do is stop those threats from arriving within country and we will be fine. I think most countries, particularly high-income Western countries, take that approach. They view diseases as being prevalent in the global south, and all you've got to do is prevent those diseases from landing on your shores. I think the most interesting thing in that regard, though, is that Australia was very, very clear quite early on in terms of its engagement with the International Sanitary Conventions of, no, we're not going to abide by those standards. And we are going to overtly declare right from the off, we're not agreeing with that. We're not following that. We're doing our own thing. I think the difference is that lots of countries agree to commitments, which they have no intention of following in the future in an emergency situation. I think that's the big difference, is that Australia was quite clear in going, no, we're not doing that. Whereas other countries like my own, took the approach of going, we'll agree to it at the treaty, but in an emergency situation, we may derogate and we may do our own thing. I think the most interesting thing, and I would rather countries take the approach of what Australia what Australia did, because at least then you know where you stand. You know whether this commitment is going to be followed or not. And one of the things that I've written about is a concern that countries will agree to commitments now, which when we need them to follow those commitments during a future pandemic, during a future emergency, they won't actually follow and don't have any intention to follow. I would prefer countries to take an Australia approach of being quite upfront and honest about the things that they are going to refuse to do in an emergency situation. But I think lots of countries take Australia's approach, just don't say they're taking Australia's approach.
It's often in those emergency situations where the national interests really do win the day.
Exactly, yeah. And Australia was quite clear about that all the way through. Other countries are less honest about that.
Jonathan, in your experience as a participant in global health negotiations, as well as working with WHO and governments to improve health outcomes, how have state concerns come to the fore, and how are they managed in those contexts?
Thanks, Esmé. And if I could just start by acknowledging that I'm joining from the unceded lands of the Wurundjeri people and pay my respects to their elders past, present and emerging. And also I'm joined with Mark and Esmé in congratulating Rebecca on a really fantastic paper from which I learned so much. And having lived through the pandemic in Australia, there's just so much history to our approach that I wasn't aware of, and it's really made me reflect on the way in which the Australian government or governments have dealt with COVID-19. So questions about state concerns coming to the fore, and I had a few thoughts as I was preparing. So one thing I think is important to say at the outset is that states generally have multiple concerns, and these often pull in different directions. And this is really evident with respect to pandemics and infectious diseases. So obviously, states have a concern to keep their people healthy and alive, but also enabling them to live lives that are as free as possible. And, there's some really, I think, unfortunate, terrible trade-offs between a number of the measures that are designed to reduce the spread of infectious disease and people's mental health, people's well-being. The concerns to keep people in work, to keep people connected to loved ones, communities, friends, keeping the economy running, keeping supply chains functioning, having enough medicines, vaccines, food, and so on. So there's really multiple concerns that states are dealing with at any one time. And of course, different parts of government very often have different and often conflicting concerns. And the more complex and wide-ranging the subject matter, the more difficult it is to reach single, coherent whole of government positions. And so, when governments are participating in negotiations, and those that I've seen most closely have been at WHO, in a formal sense, the delegate who's taking the floor is speaking on behalf of the whole government. Now, that's true to different extents in different countries. Some countries, really take whole of government coordination seriously. They'll go into negotiations with really detailed positions that have been signed off at a high level, and any departure, they've got to, particularly in Australia across the time zones, we'll call capital overnight and get back to you in the morning. And they'll, be really clear who something needs to be escalated to. It might be the Secretary of the Department, it might go as high as the Minister, or in some instances the Prime Minister. And so it's one side of on one end of the spectrum. On the other, I think I've seen this before, you do really see some individual delegates who are just making it up on the spot. They haven't spoken to anyone in Capital. Very few people know they're at the meeting. They don't really have a negotiating brief, and they're saying things that seem like they're good ideas. So I think that I won't go on too much longer. So I think those are sort of about how state concerns come to the fore within the state, or within the state's negotiating position or positions. And then if we talk about how they come to the fore in international negotiations. So just a couple of points. One is that, of course, a lot of negotiating takes place behind closed doors. And I don't mean just in the obvious sense when meetings are only open to states and others aren't allowed in, but so much of the negotiating takes place in informal conversations bilaterally, like within like-mindeds, within blocks, across blocks. So it's often actually hard to work out a particular state's position on certain things, and states, particularly who know how to play the game, they won't always have their fingerprints, so to speak, on the positions or interventions that they've had a role in initiating. So it's often you can be observing, but not quite sure how things have come to be said by who they're being said by. And then, of course, you have this sort of kind of, trading of interests in international negotiations. And sometimes what's being traded is really clear, but very often it's not. And, particularly if you think about the negotiations of complicated texts that go into the wee hours on very little sleep, it's kind of really hard to work out. So there are certain things that governments are really, really clear about. They want to be clear about. They want to make it clear to their own populations. This is the position, but there's a whole lot that you don't know. So so I'll stop there. So I think sort of the two main points are that there are multiple state concerns operating at any one time, and that even in what look like open, transparent negotiations, they're probably not as open as you might think that they are.
Thanks, Jonathan. I guess too, the federal structure of a state like Australia even further complicates that idea of what is the government's concern, and we certainly saw that during the COVID pandemic as between central government and state governments. Rebecca, you briefly mentioned your paper periodises Australia's engagement with health governance by reference to both its approach and objectives over time. To what extent do you think Australia's current approaches to international health governance are affected by this history?
Yeah, I think taking this sort of chronological approach makes it very clear that it sort of hasn't changed. And as Mark was saying, while a lot of states have the same interests and they have that same sort of ideas and sort of ideals, Australia does take a more overt approach. I think because it formed this idea very, very early on, sort of right at inception, where as soon as it was colonized, it sort of started calling it clean and new and a distant island. And it had sort of, because of this sort of the creation of the Australian identity almost appeared almost immediately. It meant that this is sort of sustained throughout time, and sort of sustains the approach. I think in 1895, one Queensland senator at one point said that, if we have a good quarantine regime, it'll give the colonies the best chance of still retaining the title of Virgin Continent. And so there was this strong idea around purity and sort of cleanliness that I think persisted. And so it meant that Australia has sort of just layered upon its policies. It had the Quarantine Act in 1908, and that really only was replaced in 2015 with the Biosecurity Act. And really it's just adds more and more layers of the mechanism to defeat and prevent entry of disease, rather than adjust to the world system. Because I think Australia's approach did work back in the 18th century, because it did take a good 10 days or a month for any ship to arrive, and it meant that disease was very obvious. And because there were relatively few arrivals, you could probably put everyone in quarantine. The problem is Australia hasn't really adjusted to the changing world, and so it still seeks to do those original policies and original mechanisms. It can't anymore, so it has to adjust them. So what was once, a very comprehensive quarantine system of quarantine every single ship that arrived has turned into incredibly broad discretionary powers, allowing biosecurity officers at the airport to stop anyone, to quarantine anyone, to do anything really. What was originally sort of handpicking migrants and having a very sort of particular migration system, well, it's basically the same, but a stronger version of that, with a stronger focus on the visa regime, whether someone is either legal or illegal, and that sort of gives greater ability to the government to manage who is in Australia. I think the fact that this sort of approach has continued is most clear by Australia's approach to COVID-19, in that as soon as it could, it immediately went back to that original sort of 18th century idea where it did want to quarantine every single arrival, complete entry ban, complete exit ban. And it sort of did take an approach that it demonstrated that it sort of did want to, it artificially limited arrival numbers through the aeroplane caps. It sort of went back to this original approach. And I think that says a lot about the sort of Australian imagination in regards to disease governance.
Thanks, Rebecca. I think one of the striking things about your paper is the use of archival sources and kind of that tracing through different periods of history to show Australia's shifting approaches to issues of quarantine and health governance over a pretty substantial period of time, 1788 to 2022. And Mark, my question for you is, how does this compare to what other states were doing over similar periods? And what did you find most surprising in reading through Rebecca's approach to the history of these issues in Australia?
So in terms of how does this compare to other states, we simply don't know, because the most surprising thing or the most interesting thing about Rebecca's paper is actually the approach which has been taken, which is so interesting and unique. And as you say, this use of archival sources, but also blending together the domestic and the international. Within sort of legal scholarship in general, you're either an international lawyer or you're a domestic lawyer, and never the twain shall meet in general. And there is so little public international law scholarship which actually looks at the domestic policy drivers for that change. And there's some of that work done in international relations, but very little of that done in international law scholarship. And the most interesting thing is just the approach that's taken, and the approach which is so comprehensive. My main thought is, Rebecca, do this for the UK as well. I would do it, but I simply don't have the patience to sit down and trawl through all of the archives which you've managed to do. But I would love to know how the UK's changing approach has influenced its negotiations within this space. So the most interesting thing is the approach which is taken, which is so interesting, and one of the things that Rebecca should really be commended on for this paper, because it's a tremendous piece of work.
Well, to all those on the call interested in these issues, have a think about which countries to profile and think about submitting to the yearbook. We definitely welcome that kind of scholarship. We've at the yearbook, we've had a ongoing engagement with the international law implications of COVID-19, and in particular, a key issue that we've seen arise within Australia as a result of COVID-19 measures have been international human rights concerns associated with travel restrictions and vaccine mandates. Rebecca, I'm interested in what your research reveals about the salience of international human rights concerns in this space. Have human rights concerns driven Australia's approaches to quarantine and global health governance, or have they remained merely an afterthought, and has that changed over time?
Thank you. Yeah, human rights don't seem to play any role. And of course, one could very validly say, well, health and access to healthcare is a human right, and there is a right to health. However, I think it's sort of important to distinguish that from a human rights approach to health. That is, Australia's approach doesn't seem to consider health in terms of being it as a right, or sort of doesn't, even when it talks about it, phrase it as a right. It seems to see and conceptualize health issues more as a potential cost, perhaps, but it certainly isn't sort of spoken about in rights terms. So this means that when the Australian governments consider their policies such as movement restrictions or vaccine mandates and that sort of thing, there is no consideration or balance with broader rights beyond health, and health isn't sort of placed in any sort of balance. So it means that the health policy is always imposed as an absolute necessity rather than any sort of consideration of rights implications. I think this was quite clear in there was a Victorian case under the Victorian Charter, and while some Australian states now do have have rights instruments, these sort of also don't conceptualize or are almost useful in terms of health governance. In a particular Victorian case, for example, it didn't concerning whether the curfews imposed in Victoria were compliant with rights. The court didn't balance the right to health against other rights, the right to private life, the right to movement, that sort of the right to liberty. It didn't sort of balance those rights. It just sort of merely relied on the public health exception and said, well, that's all that matters. So one can defend Australia's COVID-19 strategy of movement bans and entry bans on the basis that it was protecting the right to health. But none of these really sort of, the way it did it doesn't demonstrate any consideration of rights. Quarantine, actually, for example, was charged above cost, so every arrival having to be put in the quarantine hotel had to pay for it themselves. That wasn't allocated to any sort of financial means or anything. It was just sort of the cost of this, and it was because Australia didn't particularly care about the person coming home. It cared about, oh, we must keep disease out. Similarly, I think when you had to, if you managed to get past the exit ban, you had to waive your right to consular assistance as soon as you left. With Australia, therefore, sort of washing its hands of its citizens. I think this is most obviously demonstrated by the 2021 ban on Indian Australians from all Indian persons from entering into Australia, including Australian citizens, such that to Australia it didn't matter that its citizens were suffering or sort of needed to come home for any reason. Australia didn't want to risk disease, therefore there was no option for that to happen. And so I think this demonstrates the almost lack of care for rights in Australia. This, I think, can be attributed to a couple of things. It obviously could just be as we were discussing, the salience of these ideas around protection and the threat from outside. But I think it, in part, and why there was slightly different approaches in other countries that have these same interests, is demonstrative of Australia's lack of rights culture, legally and culturally. And while Australia has developed some cognizance of rights and has, so a couple of states have charters, federally there's the Parliamentary Joint Committee, there's the Parliamentary Scrutiny Act, which means that there's sort of some thought around rights, but there's not really a rights culture, and rights concerns aren't litigated. It's not like any members of Parliament raise rights concerns in their debates or anything like that. It's they're not sort of, it's not considered an important part of representing their electorate. Rights are sort of just pushed aside, and there's therefore a very weak expectations of compliance with rights in Australia, and just sort of no mechanisms to ensure rights, meaning that the policies aren't altered and the status quo, this original status quo, has just been maintained.
Jonathan, as someone who's been in Australia over this period since COVID-19 arrived, what's your take on these issues?
Yeah, so two things. One is that I just want to sort of preface my comments by saying that I don't consider myself to be an expert in either international human rights law or domestic human rights law, and I know that some of the people on the webinar are. So, and I had prepared some comments, but I was thinking if this were an international negotiation rather than a webinar, I would probably just take the floor to say I'd like to align myself with the position stated by my friend Rebecca, because I'm not sure that I have that much to add, but I might maybe just echo some of Rebecca's comments. I mean, I agree that Australia doesn't have strong constitutional human rights protections of the kind that many other countries and regions do. Various things flow from that, including or relate to it, including that I don't think, as Rebecca said, I don't think human rights generally feature all that strongly or really cut through in policy debates, public policy areas of controversies, and where we do have statutory human rights protections, or the common law has a role in protecting human rights, then courts are generally quite differential to governments' political policy decisions. And particularly, I think there's some there are some good reasons for that when you're dealing with really complex policy decisions that rely on complex scientific evidence, including social science evidence. So I think one has to be careful, I think, sometimes about how far courts should intervene. In this, I'm in Victoria, and as many know, we lived through some of the longest, harshest restrictions in the world. Human rights, I don't think, got much consideration in public debates. And at one point, I went back to check this, it was September 2020, during extremely restrictive and lengthy lockdown. Victoria's Premier said, in relation to the curfew that Rebecca mentioned, that had understandably become quite contentious. Premier said, quote, "It's not about human rights, it's about human life." And that kind of demonstrated to me that the lack of informed human rights discourse in Australia. I mean, there are at least two obvious objections to this. One is that protecting human life should be done in a way that, as far as possible, protects and promotes human rights, because human rights are essential to the functioning of societies and to human health and well-being. But second, and it felt more striking to me at the time, and Rebecca said this as well, is there wasn't a lot of kind of language to call on to argue that protecting human life does advance human rights. And I get that people often think about the right to health, the right to life in narrow terms, sort of the right not to be deliberately killed. But, the right to health is just not a thing in Australia. And I think it is problematic if, where human rights are protected and discussed, at least to some degree, it's only civil and political rights that are in people's consciousness, and social, economic and cultural rights just don't get a look in. And then just one final point, that I think there has been, since restrictions were first introduced, there's been a lot of public debate, discussion, and indeed law reform, and I've seen it most closely in Victoria. It's really been about getting the right mix of powers and oversight between the legislature and the executive. And so I just want to note that some of this, which is really about the distribution of power and limitations on the exercise of power, could probably be seen through human rights lenses, and probably would be in jurisdictions that have deeper human rights protections and discourses than Australia does. But here instead it's about the powers of the different branches of government.
And I think without those kind of embedded human rights norms, often then those issues of deference really come to the fore when you're dealing with technical and complex issues that are also presented as a threat to the life of the nation itself. So it makes for a very tricky combination. Mark, you've written specifically about the equitable distribution of vaccines and pathogen sharing. To what extent have human rights concerns played a role in how states have approached these issues, and to what extent should they?
So the first thing to say is that there is a long, despite the caveats which both Rebecca and Jonathan put in around an overt emphasis on civil and political rights being present in human rights discourses, the right to health as being a mechanism by which enhanced access to medicine can be achieved does have a long history, which goes back to the HIV AIDS outbreak of the 1980s, where we saw the right to health litigated in a number of countries around the world, particularly in Latin America and Africa and Southeast Asia, around enhancing equitable access to antiretrovirals for HIV treatment. So there are some success stories around the world of the right to health being litigated and being at the forefront of the discussion and the debate around equitable access. However, that's in a limited number of countries, and it's largely in countries which recognize a constitutional right to health within their constitution anyway, notably countries like South Africa. Scaling that up so that there is this legal basis in some countries, but a strong normative political base at the international level for discussing equitable access to medical countermeasures through a right to health framework. What's really interesting is how little of that was actually done within the context of COVID-19 vaccines. Human rights discussions where they did exist, recognizing what Jonathan and Rebecca both said about there being very little human rights discourse around the world during COVID-19, was focused largely on the interventions which government made around lockdown and civil and political restrictions on lockdowns, on restrictions of movement and so on. Very little discussion around improving access to medical countermeasures was framed within the language of human rights, which I think is interesting in and of itself. I don't know why that is the case, but it is the case. And it's interesting regardless. The other quite interesting thing that didn't come up is the extraterritoriality of our actions. Okay, so when we're talking about access to antiretrovirals for HIV and the human rights discourse around that, it's really easy to, without sort of going into this in too much detail, it's really easy to make antiretrovirals. Okay, it's really easy to make tablets. Any kind of tablet that you have to take for any condition, you can really cook them up in your kitchen if you know what you're doing. Therefore, there are thousands of potential suppliers around the world for these treatments. That's not the case when it comes to vaccines. Vaccines are far more complicated to make. There are far fewer suppliers around the world. It's really easy. It's really difficult to do. You can't reverse engineer them. So you have a very limited supply, which was dominated by a small number of wealthy countries. And that is still the case with vaccines. We've now got a bit more equity in where vaccines are around the world, but generally, particularly in the early stages when the vaccine was most effective, dominated by a small number of high-income countries. Now, a framing could be put on this of going, that is my government meeting its human rights commitment to me. Okay, it has a human right obligation to protect my right to health. But what we are failing to take into account within any of these discussions is that in meeting my right to health, we are directly limiting the right to health of someone else, particularly someone in the global south who would be far, pushed to the back of the queue when citizens like myself of high-income countries were receiving their 4th doses, and you had healthcare workers in low and middle-income countries who hadn't received one. So I think one thing that we're not really considering here is the human rights implications of us meeting our right to health obligations in high-income countries. And I think that has had sort of scant consideration right now. There is and to bring in pathogen sharing, which I've written quite a bit about with fellow Australian Michelle Rourke, where we talk about that what things like pathogen sharing and access and benefit sharing systems, which are currently being negotiated to be inserted into the pandemic treaty, do. They commercialize access to medicines around the world. Okay, so the way the system works is you as a country provided a pathogen into the international system. That pathogen was then used to make a vaccine. You're first in line to get some of that vaccine, which might work well for the country that provided it if they can use this system to their advantage. But what about the country next door who needs the vaccine just as much but didn't provide samples? What about the country on the other side of the world who needs the vaccine just as much but didn't provide any samples? Moving away from the human rights discourse into the access and benefit sharing landscape, which is what we're doing now through the pandemic treaty, seeks to transactionalize and make access to vaccines a transaction. It says you get rewarded with vaccines because you played the game properly. You gave us the pathogen samples when we needed them, so here's your reward. But what about all of the other countries that didn't play the game or didn't get to play the game because another country provided samples first? They get nothing under this system. Whereas that completely disregards the human rights claim that everyone around the world has to equitable access to medicines under the right to health. And I worry that when we look at things like the pandemic treaty, and I know we're moving on to talk about the future in a little moment, we're seeing even less emphasis placed on human rights commitments and even more emphasis placed on systems like access and benefit sharing as being mechanisms by which we can deliver equity or by which we can deliver equitable access to medicines. I think that sets a dangerous precedent. And whilst there's not a strong legal precedent with the right to health being used as a legal basis to claim access to medicines, there's a strong normative and political basis there, which has been built up over decades, and we're sort of ignoring that at our peril, I think.
It's interesting because even though we have these kind of international laws and international frameworks, it almost sounds like in terms of distributional effects, we're still very tethered to a national distribution that doesn't necessarily take into account kind of global equity and benefit sharing.
Yeah, really national in nature, but also really, when you look at the global distribution of where manufacturers are in the world who can make vaccines in large quantities, and particularly make things like mRNA vaccines, which seem to be much more effective than traditional vaccine manufacturing practices, it's almost all concentrated in a small number of high-income countries. There's nothing in the global south, or very, very little in the global south. And until we expand manufacturing capacity into those regions and into those areas, then we're going to have this two-tiered system where countries like mine, and also countries like Australia, dominate the supply. I mean, the contracts for vaccine supply for Australia were given to manufacturers based in Australia on the basis that they would supply Australia first, right? You get the contract because you're based here, and you will give supply to us first, and then we will begin exporting once domestic demand is satisfied. And that's the same in the UK. It's the same with France with Sanofi Pasteur and these companies. So that there is that overt nationalistic aspect to it, as you say, Esmé.
As you foreshadow, I'm keen to kind of shift our attention now to the future and to our attendees. This will be our last round of questions before audience Q&A. So please do have a think about any questions you'd like to ask our panelists, and either pop them in the chat or hold them till the Q&A round. Just kind of thinking ahead to the future, and I'll start with Mark. Your research engages with diseases other than COVID-19 and focuses also on pandemic preparedness. What sorts of lessons for international law do you think COVID-19 holds for future responses to other global pandemics? Oh, sorry, Mark, you're on mute.
There you go. That's a really good question, and I think there's quite a lot of disagreement within the international community at the moment about what the future holds for international law and pandemic preparedness. We are currently in the process of two major reforms at WHO. The first is reforming the international health regulations, which are the current international framework for pandemic preparedness and response, which Rebecca talks about in her paper a bit. But there's also this process of negotiating a new treaty on pandemic preparedness. There isn't a treaty at the moment. WHO has very limited experience in finalizing and negotiating treaties, as Jonathan can attest to with the FCTC. But there is this belief, what I would frame as a faith in the idea that a treaty, not just regulations in the way that the international health regulations are, but a treaty, hard binding international law, is the future for pandemic preparedness and response. And there's an awful lot of faith being put in this instrument as being able to correct lots of the problems which we identified in COVID-19, particularly problems around equity, things like equitable access to medical countermeasures, but also equitable access to PPE, equitable access to testing, to diagnostics, which gets far less attention in the ongoing discussion, but it's just as important as medical countermeasures. And the idea is that a pandemic treaty, and it must be a treaty, the negotiators are very clear it must be a treaty. They're not clear why it must be a treaty, but it must be, is the solution that we need to go down to fix this problem. Personally, I have less faith in that idea. And actually, one of the fundamental issues, and this goes back to what I was saying at the beginning, which Rebecca really highlighted in her paper, which is Australia saying, no, we're not doing that. We're not going to. We know there are these international commitments, but this is what we're going to do instead, and being quite clear and upfront about that. One of the fears I have is that countries will make commitments now in quote unquote peacetime that we know, or we have very good reason to believe, they will not follow through with during a pandemic. And my worry is that the treaty will give an illusion that we have fixed the problems when actually we haven't addressed them at all, because we can only fix the problems that we identify in the system if people agree to follow this new international legal regime. But I think there are very good reasons to think that they won't, particularly high-income nations who we've seen as being highly nationalistic during COVID-19 and during other previous outbreaks. And I think one of the potential routes that the future that might pose better options in this regard is enhanced regionalism, which is something since the creation of the United Nations and multilateralism in its present form, multilateralism has been the mechanism by which we have addressed all of the global, or seek to address all global problems, all countries united together. And the logic of that makes a lot of sense when you're talking about pandemics. We're all in this together was one of the things that we heard about from WHO quite a lot. But we weren't all in this together, and we're still not all in this together. You know, I sit here, a young, healthy man in his early 30s with 4 jabs in my arm, when we still have healthcare workers in the global south who haven't got one yet, and in some instances have had one, maybe a second dose. So we're not all in this together. And I think there's a bit of an illusion that we are. And potentially the solution to this issue might be regionalism, maybe actually recognizing, no, we are not all in this together. The needs and the desires and the actions and the resources of France and Germany and the UK might be well aligned, but they're very disparate from those same things in sub-Saharan Africa or in Latin America or Southeast Asia. So we may see more regional work on these issues. And that's one of the things that we're seeing right now with the African Union and the African CDC, who are very much taking an approach. I was talking to one of their negotiator from the African Union quite recently, who said, we're not really that concerned about the pandemic treaty. We're letting it roll on in Geneva. We're participating when things happen, but we're dealing with these problems back at home. And they use the phrase African solutions to African problems. That there's a sort of a real lack of faith in the multilateral system right now in global health. And I think that lack of faith, or that belief that multilateralism isn't necessarily the solution, might translate over to issues like climate change or regional financing and so on. So I think we might see increased engagement from regional groupings. We're seeing that with the African Union. We're seeing that very heavily with the European Union, who are engaging very strongly in global health right now, but largely to strengthen the European Union's position within global health and to strengthen health within the regional bloc rather than at a global multilateral system. So I think that's where we might be heading, or that might be the solution we are heading right now. But I don't think there are many people who have put their full faith in multilateralism, and that next time we'll fix all of the problems that we've identified this time around. I think there are good reasons to think that we're very far from doing that right now.
In some ways, it adds another interesting tension to our discussion previously of statism and globalism, and maybe we have a new trend of regionalism coming forward. Jonathan, as Mark just mentioned, you've done a lot of work on the Global Tobacco Control Treaty, the WHO Framework Convention on Tobacco Control, which I hold near and dear, having worked on the plain packaging case for Australia in my life as a government lawyer. Reflecting on that work, do you have any thoughts you'd like to share about the negotiations currently taking place through WHO on the proposed new pandemic treaty and amendments to the international health regulations?
Yeah, sure. So, yeah, I worked on the FCTC for a long time, and I've seen the many ways in which it advanced and is still advancing global health. I'm a big believer in and supporter of the value, the power of international law in advancing global health. And of course, we need international rules for pandemics and infectious diseases more broadly. International cooperation is self-evidently essential, and while some of this cooperation can be achieved through other mechanisms and means, some, and probably a good deal, does need to be enshrined in binding international commitments. And I'll park that really interesting set of questions that Mark introduced about regionalism. I'll just park that. So if we look at the current negotiations of the proposed new pandemic treaty and the amendments to the IHR, compare them to the FCTC, one thing just stands out as bleedingly obvious, which is how straightforward a treaty on tobacco control is compared to international legal instruments on pandemics and infectious diseases. And this is a really quick list. Now, given the complexity of the drivers, climate change, loss of biodiversity, ecosystem degradation, livestock trade, wildlife trade. Second, there are many health, social, economic impacts and the trade-offs that we've discussed between, slowing, preventing the disease spread and keeping societies and our international system functioning. Third, the sheer capacity needed across prevention, preparedness and response, including in surveillance and in health systems. I'm up to 4, I think, that in the the complexities, and Mark's touched on a number of these complexities in research and development, production, distribution of medicines, vaccines, diagnostics, medical equipment, PPE, and so on. And I've specifically mentioned negotiations on access and benefit sharing. How long did it take to negotiate just the PIP framework? So you were just trying to negotiate ABS for pandemics. That's a huge undertaking. Anyway, so when I look at the drafts of both the pandemic treaty and the proposed amendments to the IHR, I can't help but feel that people are just trying to do way too much in these instruments. And I don't want that to be heard as a criticism, because there is a lot that we need agreement on, and many people see the current negotiations as presenting a kind of once in a generation opportunity to improve our international legal frameworks. If we're not going to do it, immediately post, well, it's not really post COVID, but in this stage of COVID, having learned the lessons that we've learned, when are we ever going to do it? And there's a lot of politicking, posturing, tactical negotiations going on. States want to make sure that their concerns are on the table, that they have bargaining chips they need as the negotiations progress. So I get why a lot of people are trying to get a lot in there. But my experience is that when text is being negotiated, there's so often insufficient attention given to the question, how is this going to be implemented in practice? Everybody's fixated on, okay, we change that, how are we going to defining that, if we move that around to that. And we stop, people often stop looking at the bigger picture, how this all fits. And this was something that began to concern me as the FCTC conference of the parties decided to negotiate a protocol on illicit tobacco trade. And as those negotiations progressed, and I realised sort of by the day, I was very involved in the NGO side of this. I realised that by the day it was dawning on me that the sheer lack of expertise and capacity in the subject matter within health departments and within WHO. The expertise, the mandate, the resources, so much of what needed to be done was really with customs, law enforcement, police, and their international bodies, the World Customs Organization, Interpol. So, the challenge is to have the right content in WHO instruments, deliver the right interactions with the instruments of other organisations, whether climate change, environment, intellectual property trade, wildlife trade, and so on, the right form and degree of cooperation between WHO and its counterpart international organisations, as well as effective whole of government and multi-sectoral collaboration at domestic level and between countries. So, we can do the best we can, but I don't know how much it's realistic to expect. It's also complicated. And Mark spoke about there being a lot of faith in this. At least today, and in preparing my remarks, I was feeling pretty pessimistic about what is actually going to be able to be achieved. And the last point that I want to make, and this is the sort of thing that people kind of don't really worry about, but I think should worry about, is of having two so closely related instruments, the new pandemic treaty and the IHR, which we expect to be substantially amended, which will inevitably have different memberships. As we all know, the IHR operate on this opt-out basis. There's 196 states parties, whereas the new instrument will require ratification or the other forms by which you can become a party. And it is exceedingly unlikely that we will get anywhere near 196 parties to the pandemic treaty if it is adopted. And this different membership in the context of two so closely related instruments, where countries will have different obligations, like different rights and responsibilities in international cooperation initiatives, and where WHO will be trying to meet the demands of two different bodies of different memberships with different governing bodies. So this seems to me a recipe for what I'll just sort of describe euphemistically as difficulty. I believe I was going to, just before we started the webinar, sorry, I probably shouldn't do this, but you know, Mark, you're in London. Yeah, so we had to have a quick cricket conversation because the Ashes are for those who aren't from cricketing countries, the Australia England cricket Ashes are on at the moment. I think.
Where are you going, Jonathan? Don't do don't do this to me.
I think probably both Mark and I ended up coming in off our long runs, right? So yeah, sorry for the cricketing reference.
You're used to much more difficult problems in the context of the pandemic treaty, so cricket's neither here nor there.
Jonathan, you handled that so much nicer than I would have, so thank you.
I'd like to direct my final question to Rebecca. And as we've heard, Rebecca, your paper maps Australia's approaches to global health governance from 1788 to 2022. Do you think the trajectory is set in stone, or do you think Australia's approach will change course as a result of lessons it might have learnt from the COVID-19 pandemic?
Well, like Mark and John, I think I'm quite pessimistic about sort of global health governance. I think crises like COVID-19 do have the potential to be critical junctures to sort of create change and sway Australia from its set path. However, I think because the strategy worked for Australia, because zero COVID was actually for Australia's own goals, worked amazing. Like, Australia was very happy with how it did. And I don't think that has resulted in any reflection or any sort of impetus to change from the strategy. I think the strongest possibility for any change to occur in Australia's mindset is not a change from its sort of clean, it's imagining an identity as a clean island, or all of what we were speaking about it with its sort of a preoccupation with that identity. I think that would be almost impossible to change because it's so cemented and it works and it's very happy about it. I think, as we mentioned before, the most likely area for change is probably human rights. And is creating a rights culture. Countries have created rights cultures. I think there was a article by Martin Krier, I think, wrote one on the Netherlands, where the Netherlands didn't have a rights culture even in the early days of the Strasbourg, and yet it slowly developed one, and then now has quite a good rights culture. And so I think the best area and the most likely area for change is a push for something to balance health concerns, rather than changing this identity and changing this Australian imagination. I think the most likely area for change is to create a counterbalance, a different concern, a different policy consideration that can push back against that and push back on the policy rather than the identity itself. So things like sort of normalizing human rights discussions, generating a human rights culture, having that present in Parliament, that sort of aspect, I think, would be the most likely to result in any sort of change. And I think that push would need to come probably from the inside, from persons who have been individually affected by the rights by the particular strategy, and that can create the movement for that change.
Be interesting to see as well if that comes within the central government's kind of bill scrutiny approaches, or whether it's more a push from certain states that then filters through more broadly. An open question. Many thanks for this really fascinating discussion, which has hopefully prompted our audience to think of some questions that they might like to ask you. I'd like to open now the floor to questions from the audience. As mentioned, I think you can write your question in the chat or Q&A box if you'd like, or you can try raising your hand, and hopefully our tech support will be able to allow you to ask your question directly to the panel. One kind of thought, I guess, in reaction particularly to Mark and Jonathan's last comments, just while we wait for our audience to think of any questions that they might like to ask. It's interesting, kind of early in the webinar, Jonathan, you mentioned some negotiators being able to attend negotiations and basically represent their own view and their own opinion without necessarily heavy handed control from their government. I wonder to what extent you've seen that changing now that states are much more familiar with the range of sectors and areas of life that pandemics can touch, and kind of the range of government departments that are now getting interested in things like pandemic response and preparedness. Do you see a sense of negotiators being kind of more shackled by conflicting instructions, or more instructions than maybe they were previously operating under?
So I must say I've been in Melbourne for this period, and I haven't been to any of the negotiations in Geneva, and I was thinking of going to the next lot until I learned just how close they are. So there's very little that's open even to accredited observers, which I think is really disappointing. But I suppose it's a general comment, and it's not specific to these negotiations, but significant amount is about capacity. And so if you think about the lowest, and I don't want to stereotype at all, because it isn't, these things can they can come across as stereotypes. But in the lowest resource settings, when you might have only one person in the health department who's working on, or a couple of people who are working on the domestic aspects of, responding to COVID, then sending someone to the negotiation, probably one person for the negotiations, when there are multiple meetings going on at the one time. It's not as if everything takes place in the one open room, and this sort of mythical idea of everyone's equal, and if anything goes to a vote, it's one country, one vote. It doesn't work like that at all. So you'll just have some people in the room who don't really know what's going on, and that's not a criticism of them at all. It's just that they haven't worked on a treaty before, or in these negotiations before, and their content area doesn't cover all of this. So there's, as I was saying, so there is a spectrum, but everybody, even within highest resource countries where there are efforts at whole of government coordination, everyone knows this. There are tensions. There are games played between people in different agencies, and it's just, even among us, if you to try to keep in your head everything that is in the current drafts of both the RHR amendments and the latest draft of the pandemic, one human brain can't really be across it in a way that in real time you can understand everything that's being said and its significance. Is that too sort of depressing and despairing?
Well, just to come in on that and add to the depression, if I may.
Please, I'd rather that you came across as the one who was more despairing than me. So please go ahead.
the moaning Pom. I think
we call it whinging.
Whinging Pom. There you go. So I work quite a lot with governments on the negotiations of these instruments, and I've had it. So there isn't equity of arms in these negotiations, not by a long shot. Okay, some countries, some large wealthy countries, turn up with a delegation of 30 people, and other countries have one non-permanent member of staff based in Geneva, not just to do work at WHO and the 2 negotiations at WHO. They will also be covering the World Trade Organization, the Human Rights Commission, the UNEP, to cover every international institution negotiation in Geneva. So there's no equity of arms here, which means that more of the meeting reports, more of the advising, more of the discussion is being done by the countries who have the resourcing to do that. So the negotiation and the instrument is being shaped by them purely on the basis of dominance of resources, because you end up with situations where people from the one representative in Geneva from a low resource setting can't attend all of the meetings, because one of the meeting will finish in Palais and on one part of Geneva at 11 o'clock, and the next one will start at 11 o'clock on the other side of Geneva. And it has been said to me by country negotiators that they believe that's a deliberate tactic, to have two meetings on pretty much one on IHR, one on the treaty, happening on different sides of Geneva with 10 minutes between the two of them, just to cut down who can attend the meeting, who don't have the resources to attend. So this is an equity, you know, like Jonathan said, it's one member, one vote if it comes to a vote, but it's far from that. So the instrument which we get at the end of it will inevitably be will inevitably be shaped by the countries who can afford to be there, produce the meeting reports, produce all of the documents, and dominate the proceedings in this way. And one of the contributing factors to that is the totally unrealistic timeline which has been set on these negotiations. So the treaty is apparently going to be opened for signature next May. That is a hard deadline which was arbitrarily plucked out of the sky 18 months ago when this entire thing started, where we would go from having no treaty and it being, you know, notes on a napkin to a full thing opened for signature in 2.5 years. Jonathan, how long did FCTC take from conceptualization to signed?
Yeah, I mean, it was many years, and then there were six INBs, intergovernmental negotiating body meetings, but and they would have taken place over 2 or 3 years. But a lot of work had already been done in working groups and so on. So the whole process took many years. I can see there are a couple of questions. Can I just, is it okay if I just jump in? So I think, you know, coming back to my point about how straightforward and simple the FCTC is compared to this. So what could happen, and again, I don't want to oversimplify it, but what could happen to some extent is that those countries that Mark is describing, where there's really only this one person there who's multiple demands, not just in health but across. So there was an opportunity for alliances to form, you know, within regions and across regions, but often on things that were kind of totemic and really straightforward, like, is this strong tobacco, is this provision strong in regulating the tobacco industry? And people could come together on those sort of things in a way that you could understand. Now, provisions become more complicated than that. But here, you know, as we've been saying, we are dealing with just so many different areas of policy and practice that it's very hard. You can't come together on sort of single totemic things. You can choose a few, but to be across it all and to work out what's being traded.
And the substantive content of the treaty is so much more contentious than the substantive content of FCTC.
Yeah,
FCTC's fundamental principles are smoking's bad for you. Wouldn't it be good if children didn't smoke and people didn't smoke? Everyone agreed on that.
A bit more than that, but I'll take.
Yeah, but you know,
yeah.
Being slightly facetious.
Yeah.
There was universal acknowledgement that smoking was harmful and we needed to address it. There is not universal acknowledgement on A, what counts as a pandemic, B, how best we respond to it, and C, who pays for it. Yeah. There is none. The starting bases are so complex and so much more disparate than they were when it came to FCTCs, even at the starting point, never mind how much added complexity you build into it over the negotiation, as Jonathan said. We're worlds apart from these two instruments. And FCTC took years.
Well, hopefully our Q&A from the audience will lead us into more optimistic territory, but let's wait and see. So we have one question from one of our wonderful yearbook student editors, Ari, who asks a question related to Rebecca's final point. Do you think that Australia's track record throughout the pandemic as a nation which closed itself off both interstate and internationally, and any scrutiny this might attract at home and abroad, could be an impulse to chart a different course away from the mentality which has driven its approach to health governance up until now? Or would the view that the zero COVID approach was effective, albeit restrictive, prevail in this sense? So I guess that's probably for you, Rebecca, but Jonathan, Mark, feel free to chime in if you've got thoughts on that too.
Thank you, and thank you for editing my paper. I think you're one of the contributors, and thank you very much for that, and for the great question. Yeah, I think you raise a very good point, whether the scrutiny that Australia has faced, not just domestically, but also abroad, could be sort of some sort of impulse. Australia, unfortunately, it hasn't signed the optional protocol to the ACESCA, so it doesn't really, have the compliance mechanisms that would shape things as things happen, as things do sometimes in other states. But there is the sort of potential for, I think, the course to be changed by these pressures, and by international pressures, probably more likely than domestic pressures for the overall approach. Although, as I think I said earlier, I think the best hope would be for people who were dissatisfied with the approach to push for some sort of change, and push for some sort of rights culture. As you noted, the fact that it worked, I think, has created a divide. I think this also relates to how it has been politically approached. And I know in Australia, all major parties were a fan of zero COVID, but to some extent, and anti-lockdown and anti-curfew and everything became almost a marker for the right, whereas being a fan of the closures almost became a marker for the left, which I think problematizes change to the extent that you would hope that you would sort of expect that the people pushing for rights would be on the left, but they're with more progressive ideas, but they sort of agree with the current mechanisms, for very valid reasons about safety and the right to health and that sort of aspect. But I think it really problematizes the ability for change to happen domestically in this way. And I think there needs to be a reconsideration of rights and balancing internally and externally, abroad, some sort of pressure on Australia to be more of a team player. Although given that, as we've discussed, every state wants to just support its own interest, that's probably less likely to occur.
Thanks, Rebecca. Jonathan, Mark, I don't know if you have anything to add.
Yeah, just one thing I'm really conscious of is, so I over time, came to feel that the restrictions that we lived under, particularly in Victoria and the zero COVID approach, had so many negative impacts, and I felt like it was too extreme. But at the same time, I have to sort of hold myself to this idea that somebody could say to me, well, there would be lots of people who would not be alive today if we had taken a different approach. And, this is the nature of prevention. You don't know who they are, right? So you can't say, here are all the people, and I'll show you, and, we can put them in a newspaper or put them online. Here are the people who would be dead if we'd taken your approach. So I just want to sort of acknowledge that it's something that I wrestle with, and I think that we have to be honest about that when we talk about rights, and rights are important, and just to acknowledge that these trade-offs mean some people live and some people die. So it's just something that I catch myself telling myself when I start to make an argument that this has been too restrictive.
The trouble with pandemics in particularly where you don't know exactly how they're going to unfold, the precautionary approach doesn't necessarily yield victories you can claim, because you avoid the thing you're trying to avoid. I've got a comment that kind of links to this discussion, so I'll read it out. It's from Oslam de Gurley. With regard to utilising and developing human rights language, be it regionally, domestically or cross-jurisdictionally, I would suggest some realities of what occurs in, for example, mental health institutions be made more known so that lessons can be learnt akin to self-regulation. Change is possible in all of us, and the extent of possible change might be a useful focus. So really, I think, important point. And interestingly, I was reflecting on this during the pandemic, where people were complaining about the conditions in hotel quarantine and thinking about the treatment of asylum seekers and refugees. It's kind of interesting, I think, to think about these different issues in different contexts, and the extent to which we can learn from different contexts, both how things are done well in some and how things are done poorly in others. We have a question from Karen Scott, who was on the prize committee for this paper and who unfortunately is not feeling very well because she has succumbed to a certain virus from the pandemic. So she says, my question is for Rebecca. Congratulations on your winning article. It was an absolute pleasure to read. You took a really interesting and useful historical approach, and I wondered if there was anything in particular that you think Australia could learn from its responses to past pandemics, or is COVID-19 of a different order or magnitude that past lessons are of limited use?
Thank you, and thank you very much for taking the time to read my paper, and I really greatly appreciate your thoughts and comments. I do think it is interesting to consider how different almost Australia's approach was with COVID-19. I think, to be honest, that probably is due to the magnitude. Its approach to SARS was still border-based. It was still the sort of same old, we'll shut the border, but it was not nearly as severe. But that probably is because SARS to Australia wasn't as severe, despite the proximity and despite the sort of possibility for a pandemic to occur. In SARS, Australia took a much more muted approach almost, although still border-based, more focused on surveillance and that sort of similar surveillance rather than a ban approach, which is good and I think worked for SARS, but with something to the scale of COVID-19, obviously there is, it does change it, and I think it's hard to sort of say that Australia should have done exactly what it did with SARS because it was just a different beast it was playing with. With that though, I think there are lessons Australia could take with its even with its approach to COVID-19, and to adjust that to encompass sort of something more collaborative or more cooperative. Even simply listening to WHO recommendations, not doing very racist bans, paying for quarantine itself. You know, you can still quarantine every arrival if you don't force them to pay, and you know, I have other sort of human rights problems with that regard. So I think Australia can learn from previous experience of surveillance and even its most recent experience with COVID-19 and adjust these to be a more cooperative approach. Thank you.
Thanks, Rebecca. Jonathan, Mark, I don't know if you have anything you'd like to add there. No? Great. Well, that brings us, I think, to an end of our audience questions, unless any pop up in the next few seconds. I'd like to thank the three of you very much for a really terrific discussion, and to our audience for their really engaging questions. Thanks to Rebecca in particular for a really fascinating paper. We're hoping that it will be published in advanced access relatively soon, probably within the next 2 months. So keep an eye out for it. I'd like to extend my thanks to ANZSIL, to the yearbook's editorial board and editorial team, and to our publisher Brill for supporting the initiative of a Student Paper Prize. We're hoping to run a similar prize this year, so stay tuned for that. But I'd like to extend a real particular thanks to Karen Scott and Tanya Voon for their work on the prize committee, and for engaging with all of the papers that we received. We certainly learned a lot as a prize committee, and it was really gratifying to see such great work come in from around the world, and particularly to read Rebecca's wonderful paper. For those who are interested in the themes we've been discussing in the webinar, you can, while you're waiting for Rebecca's paper to be published online, check out our yearbook archive. We published a special collection of papers on COVID-19 and international law, which is well worth a read in a previous volume of the yearbook. And the forthcoming volume also features an article by Regina Jeffries and Jane McAdam on these topics, which is now available in advanced access. So if you're looking for some reading while you wait for Rebecca's paper, please do check those out. Thanks very much for joining us today, and thanks again to our panelists, and good night or good morning, depending on wherever you've been joining from.